us directions on the way forward. I also want to thank you for availing me the opportunity to be the moderator of access to justice, which is something I'm very happy to have.
Okay.
For those of you who might want to join as pro bono lawyers,
so
Kituo cha
right now, the
Sheria as a
objective
partnership
of
with men
this
organization
will
to
be to
offer you
understand the
opportunity
concept of
to
trademark and
give
service
pro
mark
bono
in the market,
service to
a
this
need
country.
for the trademark
Thank
and
you very
service
much.
mark
Dr. Komoro,
protection,
over to you.
and also how can trademark and service mark be protected, and how can you make a valid claim against an infringement, and now most importantly to look at the trademark and service mark in the digital era.
Which is very
So
important.
the most of the legislative framework that guide us, we have the Constitution of Kenya, the Trademark Act, Chapter 5 or 6, the Advocates, Marketing and Advertising Rules, we have the Banjul Protocol, the Madrid Protocol,
ranging
and
from
Mandil Convention, the Paris Convention, and the Agreement on Trade-Related Aspects of Intellectual Property,
more
famously
challenging questions
known as
of
TRIPS.
technological
So
access.
let us go into
So I really want to thank
trademark
all
and
the
service mark
presenters for
in
their
the
insightful
digital era.
abstracts that I had the opportunity to read, which explains why you are in this panel and why we came up with this thing.
Knowledge of what a
I
trademark
also want to
is.
strongly
We
encourage
can
you to
say
develop
that in
this
Kenya, the e-commerce has
beyond
grown
the
very
abstract.
much
And I will
tremendously
be in touch
during
with you in a
this
couple of
period.
days
We have seen that so many
to give
websites
you
have
guidelines on
come
how you
up.
could
We have
move them to
websites like
something
Gigi.
that
Some of
we
us
could
do
consider for
interact with
publishing
them
in
every
one
day. We
or
have
two
Soko, we have
journals
Copia,
that
Jumia, you buy,
I
and we
currently
have so
edit
many other
for the
websites where
school.
a particular
I
individual
mean, for good order, we consider
present
all
their
papers
goods
equally,
in the
so long as it
in the
meets the
market,
guidelines and
in
it
the
passes
online
through
platform,
to
where
blind peer review.
consumers
In other
do
words, the decision I
by
make is to forward them
directly.
for
So
peer
the
review
main
based on
purpose of this
compliance
presentation is to
and
look into
based on
how
quality,
can
and then
the
peer reviewers
proprietor
will
protect
make
their
independent
trademark
assessments.
from
The peer
infringement
reviewers don't
of
know
other
themselves,
people,
so they'll make
commercial
independent comments,
infringement
which I
of
will
their
share with you,
exclusive rights.
and based on your capability to your
I would
decision
like to
actually to
point
then
out this,
improve
that
based
in
on the
Kenya we have
suggestions,
no law
then we forward them
regulating
for
mostly on this
public.
Cybercrime Act, which unfortunately
as junior academics
was announced unconstitutional in the case of Senate of the Republic of Kenya versus the Speaker of National Assembly. I read this here. And also to point out, most importantly, for you to trade online, to have an online trademark and service mark that can be protected, it must have they must meet the general standard requirement for any trademark. So we have the challenges that we do face
on the ground
in
waiting
the
to
digital
access.
era when we are using
This will go to another link which I've
service
sent
mark.
to you.
There
And
is
if you haven't
the use of
received it through the
similar
regular
mark,
email channel,
there is
then get in touch
cybersquatting.
and I'll
I would
ensure
like to
you get
explain
it
this, but in the
within
interest
minutes.
of time, but if
Thank
you
you
have
so
any
much.
question, I
Let's
will
meet
be
on the other side
gladly
of
answer
the
that,
aisle.
but I'll make sure I give my email.
Thank you very much.
After
God
this,
bless you.
so in case
Bye.
of anyone who wants to reach out. So we have the secondary trademark and infringement liability. We have cost and time. Globalization is also another challenge, and lack of know-how, lack of knowledge of technology and how to protect your trademark and service mark in the digital era. So there are some of the recommendations that the study has pointed out. So the recommendation that you have to do, how are you able to protect your trademark and service mark in the digital era? How do you make sure that you have the exclusive right? How do you make sure that you maximize the financial effort that the trademark is supposed to? So you have to make sure that you do an effective research. You have to dig deep. You have to make sure that you trademark. And I'm sure that a trademark is not just a mark. We understand that it can be a sign, it can be a smell, it can be a sound. For example, if you hear the sound of an iPhone, you know it's an iPhone. That's a registered trademark. It can be a symbol. It can be anything that identify your good from the product of the other person. So make sure that you do an effective research before you start trading in the digital world. And the other recommendation is internet service provider blocking injunctions. We have injunctions. You can go to court and the ISP, the internet service provider, can block some the infringers from accessing that particular platform. We also recommendation is to make sure that the business people who are trading online, do they understand online infringement? So you have to make sure that you are constantly engaging yourself into understanding more on infringement, on online and about infringement. So the other thing is developing a comprehensive online intellectual property protection strategy. This will occur when the organization and any area in the country that deals with the intellectual property, where they develop a comprehensive online platform. And also the other thing we can have is drafting and amending laws to incorporate the online trademark protection. Like we've stated, in Kenya, we have no specific law that outlines that online trademarks, this is how you're going to protect them, this is the way forward. We have no, the only that we have mentioned is the Computer Misuse and Cybercrime Act, which unfortunately is unconstitutional. So we need, so there's a gap there. And also if you look into international law,
Wahome? Wahome, we lost you. Sorry, can you hear me, Wahome?
I think the phone is hanging. You probably want to move to the next censorship repairs.
Okay. Sorry about it. I think we'll see how we can be able to cover that remaining portion. But for now, I want to quickly go to Madam Sian. Madam Sian, you have about 10 minutes. We will listen to you. She's going to take us through globalization, legal education, and the future of law schools. Perhaps these will give solutions to all the other presentations that we have listened to. So please take us through your presentation.
Thank you so much. Good afternoon, everyone. I hope you're not. Okay, so yes. As you said, my topic is on globalization, legal education, and the future of law schools. So globalization does not have a specific definition, but in general, it could be defined as the process by which social, economic, and political boundaries have been broken down over time and integrated to become a global village. Today, people sit in one place of the world and attend meetings on the other side of the world. There's the growth of the internet, there's the growth of social media, and the world has sort of become one. Cultures have become so integrated. And now in this globalized world, some of the things that have changed have had to change the legal industry. So globalization has brought great levels of automation. For example, in countries like the UK, lawyers are no longer drafting security documents. So security documents have been standardized so much that when a customer walks into a bank, they just need to fill in their details. So soon enough, those trends are going to boil over into other jurisdictions like Kenya. And then we will see now that lawyers will not be getting legal fees for drafting charges. So what are some of the impacts of globalization on the legal profession? So first is globalization has cracked the glass ceiling. Today, your client does not need to be Kenyan unless you're going to court for litigation. If you're an expert in any field, your client could be seated anywhere in the world, and they can reach you through your email, through your phone, through WhatsApp. So really, the glass ceiling for what you can do and what you cannot do, you're no longer limited. If you're interested in a branch of law that is not available in your country, you still get to practice it and get clients so long as you're able to market to them. Again, today, the lawyer faces very new challenges that lawyers 20 years ago probably did not have. Some of those challenges is today, clients want you to be technologically advanced. They want you to be available. If you're not able to operate your email or your computer, yeah, you're probably going to lose a lot of clients. And then because clients are very exposed in this new world, the client has also changed. The client expectation is higher because they see other lawyers on TV, they see other lawyers on movies. They don't care whether the lawyer they see in a movie is American and you are Kenyan. They expect you to have an office which is as good. They expect your services to match up. And now the legal profession is special because most lawyers do not retire at the age that other professionals retire. Most lawyers are going to practice way beyond 55 or 60. So we in the legal profession we have all kinds of generations. We have the older people who probably came from service and went back to private practice, and the law schools are continuously pouring new students and new professionals into that field. Now, another impact of globalization is that there's a lot of competition now. You see, except for litigation work, as we said, because a client can get any lawyer they want, there's higher competition. Previously, a client would come to you because you're in their town, or you're in their country, or you're in their region. Today, they don't have to come to you because they can find another expert somewhere else in the world. So there's a lot of competition. And now, as the world has become more technologically advanced, the legal institution has also been forced to invest in technology, like this conference that we are having. Yeah, and then services and process outsourcing is also one of the new issues of globalization that has transformed the legal industry. Today, firms are getting into partnerships across their continent. Sometimes firms are even establishing in other continents where there's better laws or there's better terms, where it is cheaper. So firms, lawyers have different opportunities. Companies are outsourcing some of their legal work out to lawyers so that they can concentrate on their core business. And also lawyers are outsourcing some of their work to other countries where they can find different expertise or where it is cheaper to pay. So now, what needs to change in the legal education to ensure that the lawyers that we're churning out can compete? So some of the recommendations are expansion of our curriculum. As we can see, our current curriculum is very centered on domestic laws. So the world has become very globalized. As we can see, all of us on Facebook. Facebook is an American company. We're using Zoom, we're using Google Meets. All these are companies that are not here. So if you're going to train professionals that are going to be relevant in the new world, we need to expand this curriculum to also take into place aspects of international law, because if we concentrate too much on our domestic laws, then we're going to have lawyers that cannot compete with the others. Secondly, we have to look into specialization. Generally, when non-lawyers ask us, what do you do? What is your area of specialization? Most of the time, any advocate under 5 years of practice will not be able to say specifically what they specialize in, because it will be dependent to the firm that they go to, not really dependent on the education that they got. So as the world becomes more specialized, we have more need for people to be experts. So if you're a lawyer that is a general lawyer, or a lawyer in all this, a jack of all trades, eventually it will be harder for this kind of person to stay competitive in the new world. So we have to look at our curriculum and see whether now it's time to have specialization from the root, so that by the time I go to law school, I've decided I'm a criminal lawyer. I concentrate on criminal subjects. And then if I go and I want to be a business lawyer or an intellectual property lawyer, that way, by the time I graduate, my knowledge is intense. So we might need to choose intensity as opposed to extensity. And now I think in such a model, in the event that firms are hiring people with specific knowledge, they're able to find specific candidates who are specialized in that field. And in the event that maybe you went to business school and you feel for some reason, now I need something else. Now I want to be a criminal lawyer. Now you can easily go back to school and get a package that is just specialized for the line of law that you want to practice. Third, law schools, they need to have more practical teaching. I give this example all the time. And I say that when you go for CLE, now for CPDs, if it's on mergers and acquisition, there will be someone standing there defining to you what a merger and an acquisition is, which is ridiculous because if you are a lawyer, then you would understand what a merger and an acquisition. However, when you go to school, you need to be able to merge the two companies on your desk. So now, if our legal training is not so practical as to be immediately applicable, any of us who has hired a pupil, they know how hard it is to train. Yet these pupils have been in undergrad for 4 years and at the Kenya School of Law for 2 years. But by the time that they come to your chambers, you have to tell them, okay, this is how you draft a charge. This is how you draft a plaint. So we need for the training to be more practical. And now for law schools to be more practical, they have to be connected to the stakeholders. And these are the institutions that absorb these people. For example, if the law schools were very connected to the law firms, then they would be able to share their work to these students, such that by the time that student is graduating or by the time they're getting out of school, they've actually done the real work. It's not an idea that is out there. They know how to do a case from the beginning to the end. And then now we have to look at cooperation across borders. We will have to embrace more exchange programs. We will have to see if we can open our borders to take in even scholars and teachers from other areas of the world, because today the person that needs to graduate, the lawyer that we need to make is a person that understands life beyond where they live, beyond the cultures that they've been exposed to. And you see, law is a social art.
Yeah, quite a number of people
And because of that, a practitioner has to be very well versed with global cultures and norms, even if it's not the things that
I can't see them. I'm only
in
seeing you.
the
I don't
area
know what
that
has
they
happened.
live.
Do I
And
check
then
with ICT?
lastly, I recommend that
Yes.
there
In the
should be
email, in the
investment
WhatsApp,
in
here, people have said
technology.
I've joined.
For example, as you can see, if we are in Zoom meetings, today, if you only have a student who has never held a meeting with people who are in different parts of the world, they're going to struggle to do that. So from the point of law school, they need to invest in technology so that when these students come out, they're already accustomed to applying technology to their practice. And lastly, I think that many lawyers will agree with me that mastery of law is not enough for people to run successful practices. We also have to train the lawyer as an entrepreneur. And I think as a matter of necessity, the legal curriculum needs to be expanded to take in entrepreneurial units, so that when the lawyer comes out, aside from being a very sharp person, aside from being a person that has really mastered their art, they have the capacity to convert their knowledge to a brief and convert that brief to an income. I think we've seen very many lawyers who are very bright, who eventually, when they get into the market, they're not able to run successful practices. Some of them fall into depression. And then there's very many lawyers who sit at home with a lot of knowledge, but they have no idea how to convert what they know to a brief. So we have to teach lawyers how to market themselves, how to build a social media brand, how social media can be used to build their brand and to attract their potential customers, how they can create them. So that will be all for me. In conclusion, I think the future of law school, we're looking at expansion of our curriculum. Then we're looking at the new age lawyer in the globalized world must be trained in technology, in affluence, in social manners, in intelligence, in entrepreneurial skills to equip them to run sustainable practices. The future of law schools is definitely one that calls for expansion of curriculum, interaction, cooperation across borders, and great investment in technology. Thank you very much.
Thank you very much, Syrian. I would like to take a challenge on your last recommendation, where you suggest that mastery of the law is not everything, that you also need to be able to do business. I can assure you that in the next few weeks or months, you will see an attempt to adopt that recommendation in our programs, especially at the CPD. So thank you very much. And I'm looking at the time. We are just about 10 minutes shy to the closing ceremony. I've not yet seen any questions to the panelists. So unless we have any burning questions, I wish to, I don't know whether Dr. Komolo, are you on? Dr. Komolo? Well, it appears Dr. Komolo is already on the other side. So unless we have a burning question from participants, I wish to thank you very much for your participation. I can see, yes, I can see Dr. Nyachoti saying, if you have any questions, I'm going to share with you the emails of all the presenters so that if you have any specific questions that would require feedback from them, then you can go ahead and do that. So with those few remarks, I wish to once again thank you and welcome you to the closing ceremony. This one is going to accommodate all of us, so please feel free to join and let us discuss on the way forward on all these issues. Thank you very much. Let's meet on the other side.
Just as are we still the two of us?
Yes, but I've called some people say that it shows that the event has not started.
Can you access the video and all that?
I can see the video, but let me ask this. Yes?
No, yes, yes. Yeah, you're here. You're here. Yeah, good. I can see you. I can see you for the first time. Okay, welcome. Let me coordinate with others.
You're wondering whether connectivity problem.
I can't hear you there.
No, I can't. I can only hear you on my phone, actually.
That's what I'm wondering about.
Most likely you're mute. Yeah, you are mute. You need to unmute. Yes.
No. You can hear me now?
Yes. Let me leave you with Justice so that I coordinate others to come in.
No, let me prepare first.
Okay, so. Okay. See you in a bit.
I hope you are ready to be engaged by the team. We have very young scholars around to engage you on serious issues.
I will be very happy to engage as much as possible.
Not to forget your position of BBI. In view of the case by the two counties, I think the matter has gone to Supreme Court now.
Yeah, correct, for advisory. But let me ask you.
Yes.
What is the audience like?
Yes.
The audience is broad. It's broad. It consists of literally everyone. You know where you are, there is everyone. Eh?
Oh, okay.
So it consists of lawyers, it consists of students, it consists, I believe, government officials, but we put it such that on this we only interact with you and invited guests, and then they send questions.
How long do we have?
Let's talk of 1 hour.
Okay, thank you. Now give me a few minutes then.
So.
Komolo, 1 hour is question and something.
Let me try to bring others on board. Okay. Justus, can you see me?
I can see you. I can see you very well. Yes, I can see you.
Okay.
I can also see Mheshimiwa Murkomen.
Yes, thank you.
All right.
Let them work on my camera.
Okay.
You
I
can
think
see.
is listening. Yes, Murkomen, we can see you.
Okay.
I think I'm back. Mheshimiwa, are you there? Samson, are you there? Samson? Samson, are you there? Mheshimiwa, I think we are ready to start in 2 minutes. Samson, are you there?
Yes, I'm trying to unmute my microphone.
Can you unmute so that we start? I think we put people for not so long. Good.
Molo, are we ready?
Yes, we are. We're waiting for Mr. Karugan to come live.
of rule of law. And finally is that we have a duty to lead in public opinion. At the moment, there's a conversation in the public out there about BBI, about the Constitution, about so many things. And I must say this, that our lawyers in this country have done exceptionally well, especially those of you who volunteered to go to media houses, to go and have a discussion about marriage laws, about media laws, about the Constitution, about so many other subjects. And Kenyans take those issues very seriously. It contributes to the well-being of the profession, but it contributes and promotes the rule of law. We must not shy away from giving public opinion or giving our opinions publicly, but opinions that are founded in law, not intended to mislead the public and to facilitate rule of law in our country. Last is that we must be willing to give our free services to society. Many lawyers, through non-governmental organization, through their corporate social responsibility of their law firms, have done exceptionally well in providing free legal services to the needy. Because legal profession is a technical profession, we must not deny, and again, as I said, our Law Society Act itself clearly indicates that our duty is to protect and assist the public in Kenya in all matters touching and ancillary to and incidental to the law. And if that be the case, then that protection must be given to even those who are unable to pay fees. And that is why through the Law Society of Kenya, their clinics, I hope and I assume that you have a law clinic at the Kenya School of Law. We used to have one at Moi University, dedicated to giving public free legal advice and assisting members of public. And I think that's an area of law that we need to do better as a country. We need to improve in terms of assisting the needy to access basic legal services, including matters to do with succession, divorce. There are so many families that are suffering because they cannot access property that was left by their loved ones. And it's our duty, which is to promote a proper society. And we say constitutionalism is that the nation, in the country, everybody must enjoy equal protection of law. But then what do you do with access to justice? Because you must access also a good lawyer for you to have an equal protection to the law. I have said so many things, and I hope that it's somewhere near the subject that was presented to me, but I think this is an ongoing conversation. And one of the arguments is that what will then be the legal professions in many years? What will be the place of people like Okiya Omtata? Why is there a rise of the like of people like Okiya Omtata who are not trained lawyers, but are filling a gap that many lawyers should have been, should have been filling? Of course, I understand that he works with lawyers who help him draft the points, but the point is that there is a gap in the. We must ensure that there is no gap in terms of our responsibility as legal profession towards constitutionalism and rule of law. With those many remarks, I thank you very much for having me and for having listened to me.
Thank you. Thank you very much, Senator. You've literally captured everything that we envisage with this theme and the topic we assigned you. Those who have studied Kenyan history will easily know that for a long time, lawyers were a reference point on matters of rule of law, good governance, and democratization, so to speak. And their role in that space, in a historical context, can't really be wished away. So we were a bit concerned, that you have touched on the Law Society, you've touched on fragmentation, so to speak, in our profession. That is increasingly evident. We're a bit concerned that, and I think the society, broadly speaking, is concerned that the lawyers are losing their central role in constitutionalism and probably becoming over-politicized. And this, so to speak, excludes the lawyers who, by dint of being in politics, have to be partisan on certain issues. So before I invite, we have several questions, but we will limit to maybe just 5 maximum. Before I invite Justus to also ask you a few questions or engage you, I just want to pose 2 questions. First, you mentioned about the independence of the judiciary. And vis-a-vis the BBI proposals and the question of the judiciary ombudsman, which by every figment of imagination is a unique kind of proposal. What do you think is going to be the end game here? Do you think lawyers have to take a central role beyond what they are already doing? Now that the signatures are going to be collected, and assuming that there's some consensus that we need an ombudsman for the judiciary as an institution in public service, what proposal or what structure would make sense so that we don't look like we are kind of going to the decisional independence of the judiciary as opposed to other operational aspects. Also, I'm a bit interested as a law scholar, just like you, I'm a bit interested in your analogy of the role of a lawyer to society and our profession as a calling. The fact is, over the last 10 years, we've had kind of tripling of the number of lawyers. And,
Yes.
and increasingly you get so many young lawyers who are genuinely very, very concerned about their future in terms of their ability to earn a living even before responding to the calling. Because really you must earn a living before you respond to a calling. And COVID has just exacerbated this in the sense of the young lawyers that have been laid off. So I would like to get your response by moving the conversation a little bit further in terms of, is the profession in Kenya, the legal profession in Kenya, properly structured to accommodate the incoming lawyer for them to respond to this calling without having to spend outside in the streets of Nairobi or so to speak, the streets of Eldoret or KE or something like that. Let me stop there and maybe invite you to respond to that before I invite Justice to also engage you in a couple of questions that have come in, and then we'll see with time.
Thank you very much. My thinking about the judiciary, I'm sorry to say this, it may look like people keep telling me that I'm saying some of these things because I lost my my position as majority leader. So I am getting back at the president and, and all that, and I am a sore loser and all that kind of thing. But I keep telling people, for everything you do, you must do it well. And in the old days or the past days of my Jubilee engagement, I would do a lot of these things in-house, and you must give respect to so many lawyers, including the Attorney General and others, who have to advise non-lawyers or politicians who want shortcut to achieve a particular interest. But now that I'm not in that space, I can speak my mind openly and say that many Kenyans understand the provision on the judiciary ombudsman from the history. It's not just a provision that has been put there. You must understand from the context of the promise by the president to revisit, the question of our removal, nullification of our elections in 2017. And as a result of that, that one, the DCJ was charged, again, strongly believed that it had something to do with revisit, followed by president refusing to appoint the 40 or 41 judges, and up to now, if you ask around, imagine, it was 41 and one has since passed on. I don't know if he will be appointed posthumously or not, and from there, and I don't know if there's something like that, and from there, if you ask around the corridors of power why these judges are not being appointed, you are told that some are not as friendly to the executive as they should. And therefore, the executive is saying we can't appoint for ourselves 40 enemies or 41 enemies because they are not our friends. They are not friendly to the decisions we want. And then from there, you move to the question of delaying disbursements to the judiciary in terms of financial independence of the judiciary. And then now you move to a provision to appoint an ombudsman that is directly appointed by the president to investigate the judges. So that is first the history, the context points out to a mischief that is being pursued. But second and most importantly, you have this judicial ombudsman whose allegiance is to the president because he's appointed by the president. Even so, you say, vetted by parliament. How many people have been appointed and vetted in the last 5 years, but they don't exercise any independence? I mean, constitutional commissions, including human rights commissions, have been they have been populated by sycophants, people who cannot stand up to the executive. And as a result, there is no accountability, the responsibility that was expected of them. That is the fear. There is a history to it in terms of appointment. But because he hopes to join the same profession. So we can put certain measures. The current ombudsman, we have Commissioner of Administration of Justice, is appointed to look at the executive. There is an ombudsman already was put in place under Dr. Mutunga's tenure, who is an ombudsman in the judicial at the moment. But we can strengthen that by giving Judicial Service Commission the responsibility for the appointment of that ombudsman. I also think Parliament needs an ombudsman. I strongly think that there are many things that Parliament does that citizens need to have someone to complain to in terms of committees of Parliament, the institution of Parliament, Parliamentary Service Commission. We need to have also an ombudsman that can receive complaints on behalf of citizens related to Parliament. And that ombudsman can be appointed by Parliamentary Service Commission and approved by Parliament, or even we can then allow the President to appoint that one, because then we can exchange that Parliament vets the one for Judiciary, Constitutional Commission on Administration of Justice, and Parliament can allow the President to appoint. And because we have checks and balance, we can then ourselves, if we punish ourselves, up to us if we do not vet the person appointed as required. On the law as a calling, I really think that one of the questions that used to bother us a lot is that so many students are being admitted to be trained in many law schools that have come up across the country. There used to be the privately sponsored program in both Moi and Nairobi University, which were the initial public universities to allow private students, privately sponsored students, and then thereafter law schools like Catholic, Strathmore. We have all these other universities now having law schools across, and the question has always been, are we training too many lawyers? I opine differently. I believe there is a difference between training a lawyer and the practice of law, and that the competition for litigation, you know, being in the litigation sector or in conveyancing, commercial law, that is not the only place where we practice law. I had a tiff with Senator Orengo because he was quarreling with me that in Parliament that he doesn't see me a lot in courts and that I don't practice in Kenyan courts and so forth and so forth. And I was a bit incensed because he was reducing the practice of law to only appearance, you know, before a judge or before a court of law. We must first understand that there are a lot of, and if we are speaking to students per se, there are opportunities to practice law everywhere, including in church, you know. And there is also a provision in the Bible that says, I think in the book of Proverbs, that your talent can bring you before kings. The problem is that when you choose to join the legal profession, you must be patient enough, because legal profession is not enough to be admitted to bar. It's a long, tedious training. It takes you about 5 or 6 years to be admitted to the bar. And then from there, you must go through a process of learning under a proper you know, advocate in the area that you want for almost 3 to 5 years before you can say, I am able to provide proper legal services on my own out there. So my encouragement to young lawyers is that they must be ready to go through the trenches, so to speak, and be patient, because the challenges that you face are there. But there are certain period of time. By the way, Eric, this is as a matter of fact. We have so many lawyers, but we have very few good lawyers. Yeah, and you should ask yourself, why are litigants going to the same advocates when they want them represented in court, or if they want conveyancing, or they want. So it is one thing to be an advocate; it's another to be a good advocate. And if you choose a particular area to practice, you must choose and be good. If it is consulting legally, be a good. If you want to go and teach law, do an LLM, pursue a PhD, teach law, but be a good teacher. Because then if you become a good teacher, you will always attract employment here and abroad. So I think there are many lawyers, but there are very few good lawyers. So the challenge for younger lawyers is to take this profession as a calling and become good at it.
Thank you, Senator. We lost Justus. I think he's back now. I think he wanted to take you on the question of Section 4 of the Law Society. Justus, are you there? Because I have two more questions, but in the interest of time, maybe yes, Justus is back.
Thank you very much, Senator. You spoke very well. Maybe this is the time to hear your voice regarding the Section 4 of the Law Society of Kenya Act. You have actually mentioned rightly. You have mentioned rightly that the president of the Law Society actually took on the AG for failure to advise the president accordingly. But you have actually told us that sitting where you are, understanding the corridors of power, it might be very difficult to advise people who are not lawyers to have faith and fidelity to the rule of law. Perhaps you can comment to us and tell us, in the light of what is happening, that the president has advised, there is already a court order saying, please proceed and appoint these judges, 41 of them. And you have said that a country is one which protects human rights, access to justice. We have 40 courts waiting to be presented by eminent lawyers in this country. What would be your recommendation now that the Law Society took on the AG? There was no advice, proceedings in court. Two, the other question that you may want us to say is we have not had the voice of the Law Society yet regarding the PBI. You have said that the society must shape the opinion. We have only had voices of individual lawyers out there in the media, voices like yourself speaking very well. What would you say the Law Society must be seen at a time like this? And finally, my final question is this. As a senator, what do you see as your place moving forward? I remember Honorable Senator Nyong'o, during his off sessions, would have crossed to main campus and give lectures in political science.
Yeah.
Do you think it's time for you to come back to the academia now that you're not very busy? Thank you.
Welcome back.
Yeah. Can I go ahead?
Yes.
Go ahead.
Quickly, just thank you very much for the many kind words. I agree, by the way, that you may want to take on the Attorney General on his advice to the president relating to the judges. But again, like Gitu Muigai, the former AG professor, used to say, is that my duty is only to give advice. What you do with that advice is up to you, you know. And, he must be one of the guys who really faced a lot of frustrations on a number of things that he advised and people never listened. But what LSK was doing is an invitation. It was an invitation to the Attorney General to take the higher road in principle. In other countries, in principle, such a serious violation of the Constitution, somebody appoints you to go to JSC, you go and sit in the JSC to do interviews for judges. You complete the interviews as an Attorney General because you're part of JSC. You now bring names that should be appointed, and then the other person says, no, these are unqualified people. They should not be appointed. In principle, anywhere in the world, the Attorney General should have resigned because of that. In principle. So in my earlier presentation between a calling and his and a living, and livelihood, I think he chose the latter instead of choosing his calling. Because if he was to be faithful to his profession, I mean, the Court of Appeal is almost empty, you know. The judges, they are overwhelmed. Court of Appeal in Kisumu, I don't even know if it still sits there because there are not enough judges sitting there. So the point So the point we are making is that in terms of an Attorney General advising the president, you sit there for the rest of the term of the president, and he has not appointed judges as a measure and a show of your commitment to the calling of law, the best thing is to resign from the job, and you will have made a statement. In any case, you have served this country at the highest level, the Court of Appeal, and Kenyans will respect you for taking that decision. You say, you know, I have given this advice. It's not been followed. There is no point sitting with somebody who does not follow my advice. I can still serve the country in other parts, and I want to be part and parcel of those who want to pursue rule of law. Let me tell you, Justice, and I'm not saying this in vain. In the Senate, and I can tell you this, I have had to make, one day I gave the president an advice, because we are in the same party. So I did give him a written advice confidentially about over 20 laws that are being passed in the National Assembly without coming to Senate. And I told him, and that is in 2018, I told him, if you don't do something about this, it is going to lead to the nullification of all the legislation that have been passed, and which are these legislations, your legacy is anchored on them in terms of the projects that you are doing as a country. And because he refused, I led the Senate to court. That's part of the reason why I was removed. I led the Senate to court. I became petitioner number 3. You know, the court decided the other day that all those laws are going to be nullified, if they're not going to be whatever. I gave my personal advice, despite the fact that the president signed the transfer of functions from Nairobi. And I said, on the floor of the House, that this is illegal, this is unconstitutional. They ought to have been certain processes. This is not even transfer of functions. This is actually takeover of a county, because transfer of functions has certain characteristics. So it's not like something I am coming from. I'm not giving the Attorney General advice that I've not lived by, and I've not suffered the consequences of my advice. But the point is this, that you must be willing, if you have certain conviction in life, you must be willing to suffer for the things you believe in. And you must be willing to, and more importantly, the legal profession. I don't think another Attorney General in a progressive country that believes in the things we are talking about, constitutionalism and rule of law, would continue sitting there when judges whom you recommended are not being appointed. LSK, it should shock you also, and shock us as lawyers, that there is a constitutional review process that is shrouded in mystery. When we all know the past constitutional review processes, Judge Palgai, a member of our profession, chaired the constitutional review review process, CKRC, and did a fantastic job. Many lawyers, PLO, it was Gitu Muigai, Justice Elena Ola in the Supreme Court, among others, sat in that commission, and they did a fantastic job, including Tobiko, who became the DPP later. And then we came to the committee of experts led by our late brother Nzamba Kitonga and Tiendo Molo and all this team. Then suddenly, this very progressive constitution that was pursued over 20 years is being amended in at night. We are now being told tomorrow there's going to be launch of signatures. Now rumors has it that, oh, maybe even that ombudsman thing has been amended. So, recently when citizens were complaining, pastoralists were complaining, women were complaining, judges were complaining and all that, everybody goes with his complaint to a few people and he's told, okay, we'll consider you, we might add you, just be nice, we will add you. I mean, how did it happen that a constitutional review process became that shrouded in mystery and became personalized and privatized to the extent that the legal profession is not properly represented and properly participating in this process? We should support all the efforts in the remaining period that will seek to ensure that even as we continue debating and pursuing the process of amending the Constitution, that the process must be right, that the county assemblies must be given the right opportunity to make the decision with the right threshold, being pursued. We need also to know, you saw the advisory opinion that is sought by our county assembly, and very interesting, to clarify a number of things, including what will be the role of county assembly if this bill is taken there. Can one county assembly amend or not? When it comes to parliament, can parliament amend it? What was the responsibility of bringing it to parliament and so forth? So all these processes, I believe, as lawyers, we must continue informing and participating so that we don't legitimize processes that in future could be used by tyrants to even claw back on so many of the clauses in our constitution. I don't actually have free time nowadays, Justice. I'm more busier than I was before. But your invitation to be giving lectures, I do. A few friends have invited me to University of Nairobi, to Strathmore University, and you know, as a state officer, I'm not supposed to make a living from it, but I am more than willing to give as many lectures as possible as part of public duty, to share knowledge, and hopefully I retire again as a professor of law. So I'm very happy. I'll be very happy to continue developing myself in this profession. My contribution to the legal profession was in teaching law and basically consulting for as many institutions as possible on various issues of law. I didn't spend a lot of time in courts, and if I was to come back, my greatest contribution will be to go back to teaching law, but also continue advising and consulting on matters of law, and I am very comfortable and happy to do that if I'm invited again. My greatest time in practice of law is when as a teacher of law.
Thank you very much, Professor, for that, and you are sure will come knocking the doors. I will take it back to Komodo. Komodo, there are a few questions on the chat. There are a few questions. I hope you have seen them. One is from Sigay. It is asking, what advice would Buchanan give to those political, our lawyers who have political inclination? In other words, they don't respect the law as is expected. In fact, the question is so straightforward. You can tell us that. And then you may want to hear some comments from Anonymous that we have had a problem of duplicity of responsibility in this country. What is the different role will the ombudsman in the judiciary be playing? I think that's a question. The other one is the expansion of the executive and the legislature in the BPI a fair doing or an advantage to the country or a detriment? Please explain. And Konuche has commented, you might want to hear that he says that most of us are, the greatest undoing of lawyers is that we really talk with one voice. We have been infiltrated by politicians, sector interests. So I think it's important to keep having this conversation to remind ourselves of a calling. We need to stand to our true calling. I'm inspired by former President of America, Barack Obama, that he can speak and live his ideals. May I add that I'm inspired by Senator Mukome. You have lived to what you teach. Maybe you can wrap it up in those advice as you finish.
Senator, if I may add, Senator Washira is asking, first commending you that it was a great speech, but is asking that in addition to lawyers, who else do you see playing a significant role in maintenance of rule of law in a particular political economy?
There is also another question Nambira Orina has asked. Forgive me if this has been asked, but we would like to find out, to comment on the alleged reopening of post-election violence cases and the implications on the overall policy in regard to addressing the past. Those are the questions of the chat. Thank you.
Thank you. Thank you.
Yeah, we
I
can
will
take
be
those.
okay. I'll be quick. I don't think there is any problem with lawyers having political inclination. You know, in the sense that we must be in different political parties and political persuasions and pursuing political policies and agendas that could be different. What I think marrying that question of Sige and the one for Anne Konuche, Anne and I, by the way, were employed the same day at Moi University to teach. So
conflict of interest. You have to declare.
That's a great conflict of interest. Yeah. But I don't expect lawyers to speak on with one voice in terms of as members of the law society. But I agree with Anne entirely that I expect the law society to speak with one voice. The law society must find a way of speaking as the law society through the things that unite us, and things that promote rule of law, constitutionalism. We must, the problem with the politics, like now from the political side, there are things yesterday I would disagree with the Law Society of Kenya, but because of my situation today, I agree with them. So we need the Law Society of Kenya, despite the fact that its membership, including I am on this side, Mutula Kilonzo is on the other, or Otiendo Mola is on the other side, or Orengo, or whoever, myself and Kindiki and others in parliament are on this other side. But the institution of the Law Society, which is the governing body of the Law Society of Kenya, must remain to speak in one voice and must find a way how we can discuss the details how, but Law Society of Kenya as an institution must find a way of working or reserving itself at a very high stature that they can comfortably summon its members in parliament and they appear before it, because it has not only legal authority, but it has moral authority because of the work they're doing, but because of the respect they command in terms of the responsibilities and the work we've given them once we put them in office. And I think this is the kind of law society we should build. The current Law Society of Kenya trying their best in terms of promoting rule of law, but they are affected by the fact that they speak with different voices. The internal rankles, different voices, they speak, it is undermining the authority and the respect of the institution of the Law Society of Kenya. And so we should, as lawyers, as we look forward, expect a certain, or maybe we may need to change the rules and regulations and our governing laws to see how we will have a Law Society of Kenya that has one leadership that is working in harmony, and who is the spokesperson, who makes the decision, how are decisions made, and how can people abide by the decisions they make. I also want to encourage more lawyers to come to politics. We need you more than ever. The parliament is better with more lawyers, because even across the aisle, there are certain things we quickly agree that we must pursue this one and support this one because it is good for the country, for rule of law. And since we represent usually clients that, at different times, we understand when the shoe is on the other foot. So it's easy for us to agree on passing laws and making decisions that can benefit the rule of law and constitutionalism. The duplicity of roles, yes, I agree, but we need to appreciate that already the Ombudsman office exists in the judiciary. What BBI proposal was doing is to constitutionalize it, put it in the constitution. And the only thing we disagree, there's nothing wrong with it being put in the constitution. We disagree when it comes to the role of the executive in determining the holder of that office, because then if he's loyal to the executive and the executive of this country, there are other parts of the world where the president can appoint someone, and because of the ethics and the jurisprudence that has been developed over time, you can act independently without the president giving you a phone call. But because we know who we are, it's important to allow the judiciary or Judicial Service Commission to appoint the ombudsman for them. On the expansion of the executive in the BBI report, there are many things that are going to come from it. For constitutional law scholars, a lot of things are going to be written in terms of separation of powers doctrine, the presidential system of government. Can you rightly have a presidential system of government where the president doesn't sit in parliament and go ahead and have some cabinet members sitting in appointed from MPs and others not from MPs? What happens if you appoint a member of parliament from Marakwet East, where I come from, to become the Minister of Finance, and then another member of parliament from Rangwe, for example, is just an ordinary person there? You've elevated one constituency to the executive while the other one is still in the legislature. So in essence, the legislative responsibility of that one who has been appointed a cabinet secretary will suffer in his constituency. It will be conflicted in terms of oversight responsibilities, and we will have again affected the separation of powers doctrine. If we really wanted to have cabinet secretaries from parliament, we should then have amended the constitution and have a parliamentary system of government. The prime minister sits there, then the level of accountability comes in through a vote of no confidence, so that then when you have a vote of no confidence against the government, you remove everybody from that government. So those are things that if BBI amendment passes as it is, we will grapple with for some time. And I will not be surprised 2-3 years down the line, people saying, again, we need to amend this constitution and bring back the old order as it should and as it was, because again, corruption will as even become worse, because the people who should hold the executive accountable are now sitting in parliament and compromising members of parliament from performing their duties of oversight. I think somebody has challenged me that other than lawyers, who else makes greater contribution to rule of law and constitutionalism? Which other profession? I am tempted to say no other, but of course that is not true. That is not true. That is not true. But the reality is that by law, as you read the Law Society of Kenya Act, by law, it's expected of lawyers to help in promoting rule of law and constitutionalism. But that is expressed in terms as a profession. But the rest of Kenyans, every citizen, including a farmer and so forth, are expected to interpret the constitution, uphold the constitution, uphold rule of law, promote rule of law, and so forth. So I would generalize all the other professions as being part and parcel of the rest of the society in promoting rule of law. And I hope that none of them is with me in this particular conference. But I on a serious note, this is just being, this is professional jealousy. I'm trying to be as protective as possible of the law profession, but all the other professions have a role, whether it is the economist, whether it is the political scientists, they play a great role. People who are in arts, most of them are even the ones in various sectors of our society. So as many professions as possible still have a role, including the medical profession, in promoting rule of law and constitutionalism. So, okay, sorry, Orina has asked something about PV.
Yeah, that's what I wanted to think.
Yeah, the danger of what, there's nothing wrong with revisiting. I agree with the DCI when he said, oh, crime never rots. You cannot, there is no limitation of time when it comes to pursuing any crime that happened, whatever period of time. The challenge that we have in the announcement of the DCI yesterday is that it is it's an abrupt, disjointed announcement that you don't even understand where is the context. 2 years ago, the president came to parliament and said he has put in place 10 billion shillings as reparation money to deal with all matters of historical injustices, including victims of post-election violence. The president also went in 2013 with his deputy. From 2013 up to the time the cases ended, they went to UN in New York. They went to UN meetings in Europe. They went to Assembly of State Parties of ICC. They went to our AU, all countries in Africa, telling them we have sorted post-election violence. We have resettled everybody. We've returned everybody back to their land, and now this matter is behind us. So the question we ask ourselves, was the president lying when he said as much? Is it true that there are still pending issues that need to be addressed again? So the issue of the post-election violence and the DCI, if we want to go there, then let's go there systematically. The first step is to open the work report. Okay, and say there was an envelope that was going to ICC. Now, 6 people were charged. The rest of the envelope, many people were not charged. So we reopen the envelope and say, we charge the remaining people who did not go through trial in ICC, and then you go down up to the whatever level. But what the DCI is doing is as we have pointed some of us, it's just political rhetoric, political games, not appreciating that we have two critical reports that are lying somewhere, WACI report and the TJRC report. And you remember this government was expected to implement the TJRC report because it ended somewhere before 2012. So when Jubilee administration came into force, they should have put in place measures and systems that will implement the TJRC report. So we have asked today, some of us who you must have seen in some press conference, for those who will follow the news, we have asked that if that is where we want to go, let's then have a systematic, let the president address himself to this issue and go to his cabinet, release a schedule on how the WACI report and the TJRC report is going to be implemented. Then we close this chapter so that it's not being used all the time for political gain. Asante sana.
Thank you so much. Thank you so much for very, very insightful and provocative comments, particularly the last one. I mean, everyone is kind of caught off guard. For whatever the intention is, certainly look disjointed, and nobody is able to see the end game, particularly in an emotive issue like that. I just want to thank you and thank everyone who's contributed. There are so many questions that they could not ask. If we did that, we leave here at 7+. Some from my friends as well, so I have to declare conflict of interest. Before I invite the director to make some remarks and give a vote of thanks, I just want to comment on your earlier comment that somebody could have muted you. I mean, a good number of us in academia here in Kenya, including Justus, can't imagine a situation where our freedom, academic freedom, is restricted. And trust me on this, we will resist that one. If there's an attempt to limit academic freedom and exchange of knowledge and things like that. So thank you so much. Let me welcome Director Dr. Henry Mutai, who has been listening in, to make his remarks, give a vote of thanks, and then we close this officially. Director.
And you should declare a conflict of interest.
Yeah, welcome. But Kenya, Kenya, somehow we are all conflicted. You mentioned Rangwe, where I come from, so I really felt excited as well.
We thought together.
Okay.
Good evening.
Good evening to you.
Okay, I hope that you can hear me, and let me start by greeting Honorable Senator, who we used to work together with at Moi University quite a number of years ago. It's good to see you again. Let me thank you very much for having accepted to give the closing address at our second annual conference. It is a privilege and an honor for us. I was able to catch a bit of the final part of your address, but I was otherwise engaged when your speech started. But thank you very much for having agreed to participate and to join us. I am with the Assistant Director for CPD. He's having a few issues with connecting, but I'd like to ask him to come and just give the vote of thanks using my computer. So you'll excuse me if you see my name, but you see a different face behind the camera. But on my behalf, thank you. And on behalf of the Board of Directors of the Kenya School of Law, thank you very much, Senator. Let me invite Mr. Isaac Kuloba, Assistant Director, to give the vote of thanks and to close. Thank you.
Thank you. Good evening, everybody.
Good evening.
I'm glad that I've been following a little towards the end of this session, and I thank Honorable Murkamen for that very engaging discussion, very insightful. I really want to appreciate. Thank you so much.
Thank you very much.
Karibu sana Mheshimiwa, and thank you for finding time to be with us today. I would like to now give my a vote of thanks for the rest of the program from the beginning. This conference had the conference, the theme was Lawyers, Constitutionalism and Globalization, and we had 4 sub-themes: the future of legal education, judging and technology, access to justice in the era of technology, globalization and the contemporary lawyer. I know despite the COVID situation, we have had a successful conference today, and mine is to just thank everybody who participated, starting with Honorable Mr. Justice Alfred Mabeya, Judge of the Commercial Division of the High Court of Kenya, who kicked off the conference with a very captivating keynote address on technological disruption in the judicial process, opportunities and challenge. I've just thanked Honorable Kipchumba Murkomen for that powerful closure of this conference. Thank you so much. I would like to also appreciate Dr. Henry Mutai, who is our director and who has been supporting all this process throughout since the beginning to ensure that it succeeds together with the management. I wish to also extend appreciation to the panelists. They have done a very wonderful job in bringing out the issues that fall within the themes that we have been discussing. Thank you so much for your insight, for your research, and the effort that you have put in this process. Of course, the moderators, I know just Mr. Munyiti has been here, together with the rest who have been very useful in directing the themes, the discussions to focus on the areas that are under discussion. Thank you very much, the moderators who have been doing a very wonderful job. Of course, we have the online audience, very many of you in hundreds who have participated in this conference, giving your views and raising questions. Thank you so much for attending this conference, and we wish you all the best. Also, indeed, we had the committee that organized this, the task force on the conference, led by our CEO for that conference, Dr. Eric Komolo. Thank you, Bwana CEO of the task force, and you have steered well the conference until this time when we can say that we have achieved our objectives. Finally, I would like to thank the hospitality. Now there are people on the ground who have been working. Thank you, hospitality at the Kenya School of Law, for facilitating this conference, and everybody who supported. I know I may not mention each one of you, but feel appreciated for this session. And now I'd like to just conclude with a quote which is attributed to James Madison, who lived in 1751 to 1836, and he became the 4th president of the United States from 1809 up to 1817. And he said this: the advancement and diffusion of knowledge is the only guardian of true liberty. The advancement and diffusion of knowledge is the only guardian of true liberty. This conference was meant to generate not just knowledge, but also to generate debate on matters that are important to constitutionalism, to the rule of law, and to, of course, the end result is that we are to better humanity through the rule of law and all the associated parameters. At the end of it, we want to live a life that is better, that is more advanced, and that's why we had this conference. So we have had many things. We have had a lot of insightful issues, but at the end of it, let us use them to foster nationalism, rule of law, and justice to make the world a better place to live in. Thank you, everybody, for your participation, and we look forward that these proceedings will also be available later when they are published. Back to Dr. Komolo.
Thank you so much. I don't have anything more to say except to assure those who presented their papers that we'll be in touch with you during the week to guide you on the next phases of your papers before we then have the meet standards for publishing as conference materials. But thank you so much. I know it's still a long journey ahead. And by the way, we are holding this again next year, somewhere in July. So feel most welcome. And we're certainly going to invite you again, Senator.
Thank you. Thank you.
Thank you so much. You have a good evening. So you may leave at your pleasure. Okay. Okay, welcome.
Good. Yeah, I don't know what happened with yours.
It became so difficult to